I think you've got enough there to start, Mom. But we all need to be aware, right, Bonnie, that what makes me mad sometimes is I feel like the school, they have that little packet that they give us that says your rights on it. It's ironic that that's what we're talking about.
Bring that up now.
What's that?
Funny that you should bring that up now. Guess what I was going to talk about next?
But it's funny that that's what you're going to talk about, because I think a lot of times that, I don't know. I think the first IEP that I went to as a parent, I sat down and read that thing cover to cover. I don't think it helped me. And I think that that's ironic. I think that that's not indicative of most people. I think we go, I'm going to read it, and then we don't. So I'm glad that we have you to talk with here, but let's launch into that. Talk to us about that document and what we should be doing with it other than lining the cat box.
Yeah, right. Well, you can line the cat box after you read it. I mean, it's like sort of, what is it? It's like hot mulled cider season. And I decided it was a good time to remind people again that, that the district never, ever says more to the parents than, did you get your procedural safeguards? And if the parents say yes, the district will say, well, do you have any questions about them? And if the parent says no, the district's like, great, because they've satisfied that obligation under the law that they have to provide the parent rights at the time of the initial evaluation and at the time of the IEP and some other times. But I've been really telling people for the last few years, can you please read your parent rights, because even though, as Shannon said, it didn't really help her, maybe at least then you'll know what you don't know, because they use these against you. And that's what I was going to start talking about today, is kind of like, what they use against you because you don't know about it.
Can I just say, Bonnie, can I just clarify? I don't think I understood what was in the document. I think it had the potential to help me, but I don't think I understood it without someone like you to break it down for me.
Right. But the next step should be, if you read something and it pertains to your child's education and you don't understand it, that should be a red flag to you. Now, I know we all sign like our, mortgage agreements without reading them, and we sign our, dental contracts without reading them. And sometimes that works fine, and sometimes it doesn't. This is one of the cases where it doesn't. And there is stuff on the web. There's the SERR, Special Education Rights and Responsibilities book, that's free from Protection and Advocacy. You can get that and print it out. There's there's Rights Law has a variety of articles about different things. So you can at least, try to come to some understanding of what some of these things are, because they use them to their advantage. So there's a set of statutes that are for California and the parents' procedural safeguards in California, but then also it's a federal statute. So since we have people from all the 50 states, I figured I would just talk about what's in 20 United States Code 1415. And you can go back and look. It's very easy to Google special education procedural safeguards for your state. But you're gonna run into stuff like this, okay? So one of the really important things that you have as a tool is something called prior written notice. Districts are supposed to give it at every IEP meeting, and they often don't, and parents don't know that it's a way to get questions answered in a more meaningful way. Prior written notice, which is in section 20 USC 1415, says that the district has to give written notice to the parents whenever the local education proposes to initiate or change, that could be a placement or a service, or refuses to initiate or change, the identification, evaluation, or educational placement of the child, or the provision of a free, appropriate public education to the child. So prior written notice is something, folks, that you should be using to get your questions answered, including the last person that we were talking with on the phone. She could request prior written notice as to why her son is not eligible for special education with an IEP. And what they have to do is they have to not only give you something in writing that tells you what they decided, They have to give you the reasons that they made the decision they did, other factors that they considered that they didn't rely on, and what documents and other pieces of information they relied on in making their decision. So if you go to an IEP meeting and they say you can only have a 20-minute observation of the student in the classroom, you go home and you write them a letter and you say, I want prior written notice. Why is this your decision? What's it based on? Because a lot of the time they just say no to you and they don't tell you why. And we just kind of go like, well, that sucks. We don't know why, and we don't know where to go next, right? So that's prior written notice. It's very important. And it's something which the district is using a lot now during the pandemic. Rather than having an IEP, what I'm seeing districts do is they're sending out a prior written notice, and they are using that to describe, let's say, how they're going to change the child's placement from a home-based, purely distance learning program to, let's say, some kind of a hybrid program. And they're sending it to the clients. They're not sending it to me. So I have to be kind of on top of my game and make sure that I'm not missing those prior written notices. So that's one thing that's in 1415. It also provides that you can file a due process complaint, and it tells you what needs to be in your due process complaint. It tells you that the district has to write a response to the complaint. It tells you that, sorry.
It's okay. And we have a new comment that came in as well. She says prior written notice isn't something we received. We did get a date and time for the meeting that we already had. That's sort of typical fare, isn't it?
They may think they gave you prior written notice during the IEP meeting and it's in the IEP document, but if you don't think you got prior written notice, I would definitely write them and say, please give me prior written notice about the basis for whatever the decisions are that you're wondering about. So by all means do that. Okay, right in 1415, procedural safeguards notice. This tells you when you are getting your procedural safeguards, and I might say that they're giving them to you at that time because they think significant things are happening at that time. So the first time is upon initial referral or parental request for an evaluation. Part of the reason they're giving you the procedural safeguards then is because the procedural safeguards explain that you have to provide express consent for any evaluation, and that absent fully informed consent, they aren't going to give you an assessment. They also have to provide it if they file a due process complaint against you, because that's a very important, and significant legal development. If a district files a complaint against you, they're either filing because they're trying to defend their independent educational evaluation as appropriate, or they're trying to defend their IEP as appropriate. So the law requires that they remind you that there's a system in place for addressing these educational disputes, and it's not fair to you if you aren't knowledgeable about it, okay? The procedural safeguards notice shall include a full explanation of the procedural safeguards written in the native language of the parents, native language, and written in an easily understandable manner available under this section and under the regulations relating to independent educational evaluations. So that's something they have to tell you about, and they have to give you your procedural safeguards, prior written notice, parental consent, which we just talked about, access to educational records, the opportunity to present and resolve complaints, placement, and so on. So those are some other things that are in the federal procedural safeguards in 20 U.S.C. 1415. They also have to explain to you that you have a right to mediation for certain types of educational disputes. They also have to tell you that the mediator has to be a neutral person, and they qualify what it means to be a knowledgeable, qualified, neutral mediator. They tell you that the state has to bear the cost of the mediation process. They tell you.
This kind of cracks me up, Bonnie, because there's some irony here that I think, I think if I were to read through this document now, I would have a better understanding of it.
Well,
And
yeah.
because I have 10 years plus experience of this. But on the day when I first got it, which is when you really need it, that whole thing about it has to be in the native language and that has to be easily understandable. I don't think it is to somebody who's day one.
It isn't.
I think,
That's why I'm recommending that you all look at this now before you have your next IEP meeting. Today is day one, as far as I'm concerned. It can be a new day where you commit for the new year to the idea that you're no less capable than anybody else of understanding these procedures. You just have to dive in and be patient with yourself when you start to space out or feel overwhelmed, and just try to get more familiar with it.
And the truth is, if somebody, I don't mean to interrupt you, Bonnie. The truth is, if somebody has a question, if you read a paragraph and you go, I don't know what this means, the best thing to do would be to write in and say, Bonnie, can you shed light on this paragraph? I don't get it.
That, and I would also say Google it or Google Scholar it. There's a lot of information on the internet, and I don't think the information you're going to come up with is going to be so bad that you're going to be worse off for having read it. Try to get comfortable in this universe that you may be in until your child is 22 years old. And after your child is 22 years old, if you're in California, you're going to be dealing with a regional center. So you need to practice reading statutes. You need to practice reading cases. There's no magic about this, but you can get a lot of knowledge for free if you're just patient with yourself. And I understand how busy all you parents are, so I don't mean to be one of those like, go off and meditate for 6 hours today. But I'm saying this is a job that you have. These are some of the tools to make your job a little easier and help you be better at what is clearly a tough job. So
amen to that.
You are also entitled to an explanation in your procedural safeguards of how the impartial due process hearing is supposed to work. And they're supposed to explain to you that within 15 days of the filing of your complaint, you're supposed to have a resolution session. They're supposed to tell you that your complaint is supposed to be heard within 30 days of your filing of the initial complaint, unless both sides agree to continue it. They talk about what should be in a written settlement agreement if you reach a settlement with the district. They talk about, here's an interesting one. No less than 5 business days prior to a hearing, each party shall disclose to all other parties all evaluations completed by that date and recommendations based on the offering party's evaluation that the party intends to use at the hearing. So, there are things about when your evidence is due, which is essentially what that is. There's a discussion about who cannot be a hearing officer, and that would include being an employee of a state educational agency or a local education agency, or a person having a personal or professional interest that conflicts with the person's objectivity in the hearing. What would that be? Well, let's say you had a side business getting Chromebooks for the district, and the district gave you certain things back in exchange for doing that. They also talk about the subject matter of the due process hearing, that if you don't raise issues in your complaint and give the other side notice of what you intend to take issue with, you can't raise things for the first time at a hearing. They also tell you about the statute of limitations and that you have 2 years to bring a case. A parent or agency, that's the district, shall request an impartial due process hearing within 2 years of the date the parent or agency knew or should have known about the alleged action that forms the basis of the complaint, or if the state has an implicit time limitation for requesting such a hearing under this subchapter in such time as the state allows. So parents, you need to be aware that if you have a really, really, funky IEP with the district and you think they're liable for it, you need to keep that date in mind, because you can't raise it if it happens more than 2 years prior.
We got about 1 minute left, Bonnie, but can I just say, I feel like this was the hardest part for us, dealing with school. And I couldn't have made it through without you. I really couldn't have. And I'm so deeply appreciative of you, because I feel like this was the hardest stumbling block for us. There were other stumbling blocks, but this was the hardest. That it was so hard to have to go in and fight for what we knew our rights were, that I had to be up on a whole set of things that I just didn't, because I'm an educator and I worked in schools, and the fact that I had to go in with, a fork and a knife and a pitchfork in the back behind me to go in and fight for what legally I understood was our right. It was exhausting. It was emotionally challenging. It was really, really, really rough. And I couldn't have done it without you. And I'm so glad that I'm through that portion of the program.
Yeah, and me too. And I had to get outside help. I didn't understand anything about the IDEA when my child got identified with a disability. But the point is, Shannon, you learned.
I did.
This is really about, what I've just come to believe so much as an older adult, which is we feel best when we have agency in our lives. And the disability seems to make it very hard to have agency over the disability. But this is something we can do.
Yeah, you're right.
And so,
You're right.
time I'll pick up and finish this next week.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.